Thank you for listening today. You know, over at HughHewitt.com, there is an Alliance Defending Freedom banner at the top of the page. I need you to support the most effective civil rights organization in America, defending our first freedom, especially religious liberty, as they did through the agency of John Bursch, former Michigan Solicitor General, ADF counsel, in a Supreme Court case argued on October the 8th, RG and GR Harris Funeral Homes versus the EEOC. Mr. Bursch, welcome to the Hugh Hewitt Show. Great to have you on. Good job before SCOTUS 2 weeks ago.
Thank you. Thank you, Hugh. It's great to be back.
It's great to talk to you. Now, I wrote a column about this on Saturday for the Washington Post because I was so stunned by Justice Gorsuch saying to you from the bench, or actually I think he said it to the opposite counsel, that the case was really close, and then he added, assume for the moment I'm with you on the textual evidence. How did that sound to you, John Bursch?
Well, I don't think the case is close. And just to refresh everybody's memory, Harris Funeral Homes is about the meaning of sex as a matter of federal law, in particular in Title VII, which since the mid-1960s has prohibited discrimination because of sex. And no one at the time Title VII was enacted, no courts for many, many decades after that, no agent of the federal government for many decades after that ever thought that sex meant transgender status. And so the text isn't close. Standing in the courtroom and hearing Justice Gorsuch say that to opposing counsel, I think he was just trying to make a point. Assume that someone thinks this is a close case. Don't you think that we need to let Congress do the heavy lifting here and actually amend the statute if you want to change the meaning of sex? So I hope that's certainly where he was going, because on the merits, there's nothing close about this.
I wrote in my post column, quote, if Justice Gorsuch so holds that sex includes transgendered status, it will be a catastrophic blow to the originalism and textualist movement. Do you agree with me?
I absolutely agree with that. And just so everybody understands, an originalist, a textualist like Justice Gorsuch and the other conservatives on the Supreme Court looks at the original public meaning of words at the time that they were enacted. And more than half a century ago, when Congress used the word sex to describe what type of employment discrimination was prohibited, there is not a single person in the United States who would have understood sex to mean something other than biological sex that was fixed, immutable, and easily determined. It certainly did not mean transgender identity.
Now, textualists do not put much stock in legislative history. There are exceptions to the rule. For example, the 14th Amendment, it was not intended to allow Plessy v. Ferguson's majority to call separate but equal. And you can elucidate what the public understood if the legislative history is overwhelming. I don't think did they attempt to argue that there was anywhere in 1964 or in subsequent amendments of the Act anyone saying that this applied to transgendered people?
No one. In fact, that concept isn't even referenced in the legislative history back in the 1960s. When Congress made amendments to Title VII in 1991, many years later, they specifically made amendments that rejected other court decisions that they didn't like, but they didn't make any amendments in response to decisions consistently holding that transgender status was not covered by the Act. And maybe the best evidence of subsequent legislative history, when Wisconsin in the mid-1980s added LGBT protections to one of its statutes, everybody hailed that as a significant breakthrough in civil rights protection and continued to do that as subsequent states made those adoptions, when apparently we should have realized all along that those were superfluous because the federal government had already extended those protections many decades earlier. The whole thing is preposterous.
It is preposterous, but in fact, if it passes, if 5 justices uphold the radical understanding of the 1964 Act, the court is unbounded, Jonathan. It really doesn't. Words don't mean anything, or words can change, I guess. And then whatever it means today will be up to 5 people. Do people understand the stakes of this case?
I don't know that they fully appreciate that because the media has done a very good job of keeping that point under the radar. They've made it a case about LGBT rights, but it's much more important than that. The case is about nothing less than whether we're going to continue to have a government of laws where citizens and businesses can rely on words as they're written on paper, or whether we're just subjected to unelected bureaucrats and judges who can make words say whatever they want.
It's also about separation of powers. The fundamental underpinning of liberty is in the division of powers, as the Federalist Papers made clear. Did anyone raise that issue from the bench when you were arguing that this is about the first principle of American liberty?
Well, yes, actually, several of the justices brought that up. Justice Gorsuch, kind of maybe in an obtuse way, in the statement that he made, was referring to that. But Chief Justice Roberts and Justice Alito brought out that point much more explicitly, that if you want to rewrite the law, that only Congress can do that. And here we all know, going all the way back to fifth grade government class, that it's the legislative branch that gets to change the laws, and the judicial branch only gets to interpret and apply them. And what the other side is asking in Harris Funeral Homes is not to interpret Title VII, because everyone knows what Title VII means. They're asking for the judges to just redo it.
John Bursch, you did a great job before the Supreme Court. Alliance Defending Freedom does a great job every day. Hey, America, call and support their work. 866-700-1060. 866-700-1060. One more time, 866-700-1060.